Well, good morning. My name is Jose Alvarez. I'm the faculty director of the US Asia Law Institute, and this is our last speaker for the fall term. We're very excited. It's the topic and both the topic and the speaker. Before I turn to that, though, I want to just remind folks who have been our dutiful listeners that we are now going to take a break, a holiday break, as the students from NYU go into the exam period. And we will relaunch the speaker series on January 26th at 9 a.m. Eastern Standard Time. And our guest then will be Michael J. Green, who is the Senior Vice President for Asia and the Japan Chair in the Center for Strategic and International Studies, CSIS, that many of you may be familiar with. The launch will be for our speaker series, and it will be the first of the year's US-Japan short takes. So it's a 60-minute program. And Mr. Green will be talking about line of advantage, which is his view of the grand strategy of Japan's foreign relations. We're very excited that that will be our opening act for the new year. So today it's my great pleasure to introduce James Bacchus. And if you are a trade specialist in the United States, you won't have to hear another word because you know this bio. He's been described by some media, and it's not really that much of an exaggeration, as the John Marshall of the World Trade Organization. And the reason for that is he's had the privilege of being a negotiator for the United States, one of the leading people in Congress, where he served for a number of years, and not just on trade issues, but certainly a leader on everything from the NAFTA to fast track over the many years he was in Congress. And then as one of the people who served for the longest term and had some of the most interesting collection of disputes as a member of the Appellate Body of the World Trade Organization. He is now a distinguished university professor of global affairs, director of the Center for Global Economic and Environmental Opportunity at the University of Central Florida. He has published a number of very well-received books in this area, including Trade and Freedom, The Willing World, Shaping and Sharing a Sustainable Global Prosperity, and The Development Dimension, Special and Differential Treatment in Trade. He has a forthcoming book, and I hope he'll draw from some ideas in that book, called Trade Links, New Rules for a New World, coming out from Cambridge University Press in 2022. And of course, some of you who follow the USALI activities will see that he has a perspective essay that I suspect will give us a bit of a sense, those who've read it in advance, of some of the things he might have to say. But our hope is to have, after a short presentation of his view of 2 decades of China in the WTO, his view of what that has meant, especially from the United States perspective. After that, we will have an engaged conversation, I hope, and I draw your attention to the Q&A box. So at any time, you can write in your question, and I will try to draw from those and put them into our conversation as we proceed. So with that, Professor Bacchus, on to you.
Thanks so much, Jose. I started young, and I seem to be almost old enough now to serve on the Appellate Body, so I'd forgotten half of that. But I appreciate you saying all that. It may give our listeners some perspective of where I'm coming from in my remarks. Succinctly, let me say that I'm someone who has spent much of my life doing all I could to advance free trade, multilateralism, and the international rule of law. I still believe in all those things. increasingly, that makes me stand out in the crowd. But nevertheless, I think that is the way forward now, as it has been since the conclusion of the Second World War. So I certainly believe in the system of liberal internationalism that we created during that moment in world history in which we had an opportunity to look beyond our own shores and make something new. Ideally, this should be a similar moment here amid this pandemic and amid all the disruptions in the world economy. I hope it will be, but it doesn't seem to be happening just yet. I believe I have a duty of optimism. I'm with Karl Popper on that, and I try to live my life that way, but it's difficult to discern reasons for optimism in much that surround us, especially on the relations on trade between China and the United States, and also, importantly, China and much of the rest of the world. As I pointed out in my essay a few weeks ago in Geneva during its periodic trade policy review, China was confronted with a grand total of 2,562 questions from 39 different countries about its alleged failures to comply with its WTO obligations. In my view, taking a longer view, we have here the proverbial glass that's either half full or half empty. I'm mindful that since 2001, when China acceded to membership in the WTO, there have been many internal reforms in China that have been made in order to comply with China's WTO obligations. But also it's true that very many of these questions that were posed to China a few weeks ago have considerable merit. That there are many aspects of the Chinese economy and of the ways in which the Chinese government manipulates the Chinese economy. And they call into question whether China is in fact as much in compliance with its WTO obligations as it should be. The list is long of these concerns. They're U.S. concerns, but they're also the concerns of many of China's other trading partners, the European Union, Japan, others. Violations of intellectual property rights, provisions requiring forced technology transfer, trade distorting subsidies to state-owned enterprises, data localization requirements, a lack of transparency. The list goes on. These are all legitimate questions. Some of China's trade practices fall within the scope of existing WTO rules. So there's the potential for China's trading partners to come together to bring claims against China in a WTO dispute settlement. In other areas, WTO rules either do not yet exist or they're insufficient. One of those areas is foreign direct investment, where there are only bare bones WTO obligations. Another of them is the question of overcapacity in steel, aluminum, and perhaps other primary products. Those rules don't exist. We have WTO rules governing situations of short supply, but not of oversupply. Dating back to the end of the Second World War, when these rules were written, I don't think countries then could even imagine, amidst the hunger and devastation in the aftermath of the war, that there could be such a thing as oversupply. But here we are. At the same time, I think it's important to understand that China has legitimate concerns. China has been victimized, especially by trade remedies imposed by the United States in a way that's often outside the scope of the obligations in the WTO rules on anti-dumping measures, countervailing duties to subsidies, and more. There are also agricultural subsidies that concern China. China has those subsidies of its own, but so do we Americans, and our friends in Europe do as well. These two distort the global marketplace, often to the harm of what should be the trade opportunities of many poor developing countries. So it's not as if we are alone in having grievances against China. They have some legitimate grievances against us. Now, because I am a free trader, I think the answer to many of these questions is to lower barriers to trade. Unlike our current United States trade representative, I'm willing to say that in principle, lowering barriers to trade is a good thing. Also, I think these grievances in trade should be settled within the WTO dispute settlement system and not outside of it. One of my problems with the so-called phase one deal that former President Trump cut with China is that in its very nature is a transactional deal dictating market outcomes. It discriminates against China's other trading partners. It diverts trade. And this, to me, is a violation of one of the fundamental rules of the trading system, the most favored nation treatment rule, that says that one cannot discriminate between and among one's trading partners. Any advantage in trade that you give to one member of the trading system must be given immediately and unconditionally to all others. This is Article 1 of the GATT. And also, I believe that these grievances should be dealt with within the dispute settlement system that upholds the international rule of law. And here we have an increasing tendency by the United States to go around the dispute settlement system. The Chinese have been much better about their willingness to participate in that system when they're brought to the bar of trade justice by their trading partners. But in looking at how the United States is looking at these issues now in the new Biden administration, I'm not certain that they're entirely committed to upholding the rule of law by lowering barriers to trade on a multilateral basis. Trade is a part of all that concerns us in the world, but only a part. It's part of what my new book, Trade Links, is about. And much of all that concerns us in the world, including especially climate change and biodiversity, to ecological crises that can not be ignored, can only be resolved if China and the United States work together. There's a mutual interest there in making certain that we have a habitable planet in which to live. We can deal with our political business as we must, but we can't do that unless we have air to breathe and productive land and clean water and an environment in which humanity can continue to survive and succeed. And therefore, we need to return to what the evolutionary biologists tell us is the core characteristic of humanity that enabled us to get thus far among all the many species of life on this planet. And that is our ability to cooperate. So I believe it's important that we have places where we can cooperate. In trade, we have created the WTO. I find that now, 20 years ago, it's impossible to think that we can have a truly world trade organization without China, the most populous country in the world. Yet at the same time, 20 years on, there are a lot of legitimate questions about whether we can have a world trade organization with China. Can we actually address these seemingly intractable trade differences within a multilateral context that is based on the international rule of law? For anyone from China who may be listening, I congratulate you on 20 years in the WTO. For everyone who's listening, I say that this is the time now to revive the WTO and return it to its rightful place at the center of world trade, so that we can increase the volume of trade and the gains from trade for everyone, and also begin to modernize and reshape the trading system into an affirmative action agency for achieving sustainable development. That should be the principal goal of this system as we approach its 75th year. Jose, I'll stop there. When I was in the Congress, I learned that listeners are far more interested in asking their questions and getting answers to their questions than they are to any presentation. I believe especially that the press at Gettysburg was probably foot tapping its way through the Gettysburg Address by Abraham Lincoln, hoping he would open the floor to questions. I suggest that at first you and I maybe engage in exchange, and then we leave plenty of time for all the others who are watching and listening, wherever they may be.
Well,
again, thank you for this invitation.
Well, thank you, Professor Bacchus, for that. And actually, this time, I'll in order to encourage listeners to put down the questions, I will actually start with one of the questions put there by one of our steady and reliable listeners, Kenneth Wasserman. And he asks, he picked up your reference to the international rule of law. And he was asking what you understand by that. And it's interesting because last night I participated in the City Bars program, which was the international rule of law and what they considered to be three global challenges: pandemic, relief and mitigation, climate change, and cyber threats. And what I, started my presentation was, here are the characteristics that most people think are part of the national rule of law, and that Kofi Annan at least thought you could expand to the planet. But my suspicion is that you have something even more basic in mind, which is if you commit to a treaty, you abide by it. But what do you mean by the international rule of law?
Well, let's start with the rule of law itself. In sum, I would say that with the rule of law, everyone is equal before the law, and the law is applied to everyone equally. This is not a novel innovation of mine. This is John Locke. And I agree with Mr. Locke on this issue, and so have a lot of other people since. So that's the rule of law. And in my view, quite simply, the international rule of law is the system in which those same principles apply to relations between and among nations states. I mean, out on the frontiers of public international law, we're quite rightly talking about new political actors, but and I'm in favor of that. But for the most part, with the international rule of law, we're talking about relations still between nation states, and thus applying those principles. You would have to say that within the WTO, all 164 of the member countries and other customs territories are equal, and furthermore that they are treated equally. In dispute settlement, this should apply most of all, and in order for it to apply, you require what I and quite a few other people consider to be most essential to the rule of law, which is independent and impartial judges. The problem in dispute settlement lately has been that in its opposition to the appellate body, to my mind, the Trump administration for 4 years was trying to make the appellate body something less than independent and impartial. And frankly, I've heard no word to the contrary from the Biden administration. They have said they share the Trump administration's views about the appellate body. I find that very disappointing, especially as a Democrat, that my own party should not be standing up as it needs to do for the rule of law and world trade. I went to the WTO in the first place back in 1995 when I was appointed as one of the founding members of the appellate body for two reasons. One, because I believe in free trade. I believe that lowering barriers to trade can vastly enhance the opportunities worldwide for human flourishing. And second, I believe in the international rule of law. And I wanted to prove that there could be such a thing as the international rule of law by making the appellate body a shining example of it. And I'm of the view that we did that for a long time. But now the United States especially has gotten cold feet, because the essence of the rule of law is that when you lose a case, you have to be willing to say, well, I lost this case, but that doesn't mean I want to destroy the court or vilify the judges. I can tell you that I did not think much of the decision of the Supreme Court of the United States in Bush v. Gore 20 years ago. But I have not spent the past 20 years trying to abolish the Supreme Court of the United States. That's the rule of law.
Great.
That's the test of the rule of law.
Well, thanks for that. I suspect this will come up, especially when we talk more about the appellate body. But I guess I wanted to push you a little bit on whether the WTO as established, and even when China acceded to it some 20 years ago, is fit for purpose. I guess I'm trying to get your reaction to those who say that the basic assumptions made by the WTO are about market states, and that many of the rules are ill-suited to a state like China, and it's only become clear over time. And therefore, if we expect this to work in the future, and we don't expect to reform China's basic governance structure, and it's still committed to SOEs and all that means, that we have to change the rules in order for people to feel comfortable that China should be in the organization and compliance with it. What do you say to that? Is the WTO fit for non-market economies?
Well, often overlooked is the fact that China is not the only statist economy in the WTO. There are quite a few other WTO members where the government occupies a large part of the economy. And yet we're not asking these questions. Is the WTO fit for purpose for Russia? Is it fit for purpose for a lot of the other countries that, while not authoritarian and while much freer, are nevertheless countries in which there is a large governmental presence in the direction of the economy. Now, China is unique in its size, and also it is authoritarian, which has many implications for trade and other aspects of commerce, as we're learning more and more. But I would say, for the most part, the WTO rules that have long existed are highly appropriate for China now, as they are for other WTO members. The MFN obligation, the national treatment obligation, the obligation to adhere to your commitments on trade concessions. These are the most basic of WTO obligations. The two further points. First of all, it puzzles me that people say this when there are certain aspects of China's commitments as a member of the WTO that have not even been the source of claims made against China in WTO dispute settlement. China made a special commitment in its accession agreement not to require forced technology transfer. This is a legitimate and a serious concern of the United States and of China's other trading partners. Why has no one brought that claim in WTO dispute settlement? Several years ago, I co-wrote with a number of my Cato colleagues a paper in which we basically outlined a legal case that could be made against China and identified all the claims under China's existing policies and under existing WTO rules. No one's taken us up on that. Presumably that's what the Biden administration is trying to work on, but they haven't said so yet. And then there are other areas also where, yes, it's true, there are no WTO rules. The answer there is not to abandon the WTO, it's to negotiate WTO rules. And I would ask there, for example, even outside the WTO, well, why are we not pushing under the Biden administration for a bilateral investment treaty with China? That seems to have been abandoned altogether. And what legitimacy is there in throwing our hands up and saying, well, there are no rules when we fail to try our best to negotiate them? Obviously, China is responsible for the fact that we don't have these rules to a great extent, but we're not even trying to negotiate them Now, my view is that this must be considered in a global context. Overall, I think WTO rules remain fit for purpose for the 21st century, but nevertheless, they were written in the 20th century. And so there are many, many, many examples, to my mind, of new rules that are needed within the system in order to make it fully fit for purpose for this century. That's what my forthcoming book is about.
Well, that's great. You've touched on actually a number of the questions that I see already in the Q&A box. For example, one listener says, can we have one WTO but two systems, the US and China, borrowing, of course, from China's approach to the two systems way of characterizing, for example, Hong Kong and also sometimes.
And how did that work for the Hong Kongers?
Right. So I guess your answer so far is that no, there's enough there, and certainly enough that can be negotiated so that we don't have to decide that some things are just not doable within trade. Is that a fair point? Or do you agree with, I guess Greg Sheffer has stated that we should revisit the types of things that we allocate to the multilateral system and say that, well, from now on, certain things should be reserved to unilateral action and it will not be deemed objectionable as a violation of the trade system. Other things should be left to regional organizations, and some things are legitimately a smaller number, presumably, in the WTO. What do you say to that?
Well, Greg is a very bright guy, an outstanding scholar and a friend of mine, but I just don't agree with him on that. I think that opens the door to protectionism and to geopolitical trade blocs. Now, de facto, we do a lot of that now because of our failure in being able to move forward globally through the multilateral trading system. We have hundreds of regional trade agreements, and some of them are better than others. In the best of them, we have innovative rules that deal with a lot of the areas in which there are no specific rules yet in the WTO trading. Digital trade, for example, and several of these agreements is one. So more ambitious rules on the link between trade and the environment is another. Now, my view is that instead of abandoning the effort to write global rules, we should be taking the best of these bilateral and regional rules and trying to globalize them in some fashion. And I do not agree with some that this ends up with us having the lowest common denominator. That's not what happened with the GATT. That's not what happened to WTO trading. Also, I believe that by proceeding on a plurilateral basis within the WTO, we can do these same things in a better way while creating the potential for additional WTO members to join these arrangements when they're willing to assume the obligations. Had we done that with the Trans-Pacific Partnership, now the CPTPP, had we negotiated it as a plurilateral agreement within the WTO, it would not have this geopolitical dimension about encircling China, containing China, because China, as a WTO member, would have been able to join the agreement anytime it wished, so long as it was willing to comply with the obligations in it. It wouldn't have needed the permission of the other members to join as it does now. So I think that suggestion heads off perhaps in the wrong direction.
So you mentioned forced tech transfer as one of the complaints that the US or perhaps other states should credibly bring, assuming the dispute settlement system were back in operation. And there was a question on just precisely what kinds of complaints the Biden administration could bring other than forced tech transfer. So could you say a few words about other kinds of legitimate complaints that the US and other states might be able to bring and presumably win?
Well, let me start with intellectual property. After I left the appellate body, I went into private practice of law for a number of years, and as a private practitioner, I was lead counsel for the U.S. Motion picture, music, publishing industries in the two cases that were brought against China by the United States relating to copyright piracy and audio visual restrictions. The United States won both those cases. I think I can rightly say that I've brought in two more cases against China than Donald Trump did. But we had wanted a much bigger case. We had wanted a much broader case, and we were unable to get the Bush administration at that time to bring it. There are affirmative obligations in the TRIPS agreement, the intellectual property agreement that's part of the WTO treaty for our listeners who are not into all these acronyms. And these obligations include an entire chapter that requires enforcement of intellectual property rights by WTO members. We wanted to bring a case challenging not the Chinese laws on the books on intellectual property, which are pretty good, but the actual enforcement of intellectual property rights in China. That case is still waiting to be brought, and it could be a case challenging the entire Chinese system of enforcement as it relates to numerous products. On the issue of industrial subsidies, I think we need tougher disciplines. We need better and increased rules. But at the same time, the existing rules on subsidies offer claims that can be made challenging a number of China's current subsidies and other practices as they relate to their support for state-owned enterprises. There, I have to say that I believe the appellate body was mistaken in taking a narrow view in a case sometime back of what a public body is under the subsidies agreement, but I think that left out entirely too much that can be directed and controlled by government. But nevertheless, I think there's potential for these cases. The Obama administration filed a case on agricultural subsidies and won it in the WTO against China. I think the same can be true with a lot of these other subsidies. A lot of what China is doing is just basic discrimination. It's either discrimination between and among its trading partners, which is an MFN violation, or it's discrimination more often in favor of domestic products over like imported products. And these can be challenged under Article 3 of the GATT. And forced technology transfer, I've already mentioned. There are other special obligations that China undertook under its succession agreement that other WTO members don't have. And these too offer some challenges. There is a long list of claims that could be made in dispute settlement, but have not been by the United States and by its trading partners. I should add that when it has been brought to WTO dispute settlement and when it's lost, China has largely complied with the WTO rulings. Sometimes they're taking a bit of time to do so, but I would argue that their overall record of compliance with WTO dispute settlement rulings is at least equal to ours.
Well, that's interesting because we're in the grading part of the show in academic institutions, and I was about to ask you the grade you would give each of the states, US and China, with respect to compliance, but I think you've answered it. I guess both of them would get the same grade. Is that fair?
No, because there are two aspects to compliance. One is what you do day to day, and the other is what you do to comply once you've been called out in a court of law.
Mm-hmm.
In terms of what's done day to day, I don't think there's any question that the United States far exceeds China in complying with its overall WTO obligations. We're not perfect. And the more we slide down the slippery slope into mercantilism and managed trade, as Trump did and as the Biden administration seems to be continuing, the worse our grade will be. But for day-to-day compliance, our grade has to be much higher than China's. China, for a time, I think, early on, you could grade on a curve. In its first decade of membership, as it tried to completely change much of its internal economy. I mean, I remember when China was actually using WTO compliance as an excuse for making changes against resistance out of the provinces in areas that actually weren't within the scope of the WTO treaty. They used it as a leveraging tool to make some other changes they wanted to make. But we have to be realistic about what's happening in China now. Since 2013, with the ascendancy of Xi Jinping, China has been turning away from the previous policy of reform and opening up. She still engages in that rhetoric, but that's just rhetoric. They've been cracking down on their own private sector, and that's short-sighted on their part. But apparently she perceives this as necessary to sustain himself in power. So realistically, in terms of WTO compliance and a lot of other things relating to their market, they're going in the wrong direction now.
So you've mentioned cases that could be brought, and I guess there were two other areas that you had mentioned as complaints brought against China: data localization and lack of transparency. And I guess with data localization, there's a broader claim that we really need a whole new set of disciplines with respect to cyber commerce. Can you say a word about, are there conceivable claims that could be successfully brought against China because of data localization, even absent a whole new regime on e-commerce and so forth?
Yeah, I haven't looked into that in any depth, but conceivably there may be some aspects of the general agreement on trade and services that may lend itself to claims relating to that and some other aspects of digital trade. However, I'm of the view that we very much need a new set of rules in the WTO relating to digital trade. And this is one of those areas in which in some of the bigger and smaller regional trade agreements, we've had some pioneering provisions that can be taken to the WTO. It can't exactly be copied and pasted, but there is a consensus on some basic things. At the most basic, no one likes spam. And there's some basic necessities, ingredients of a digital economy that require some basic rules, digital identities, for example. But then you get into tougher issues. Privacy is certainly one of them, but these other more protectionist aspects of digital trade are equally high on the list. I've written an entire paper laying out what I think should be in the WTO rules on digital trade. For those who are interested, you can simply Google my name and the title of the paper, which is called The Digital Decide. And it lays out what I think should be a part of that agreement in some detail. And I talk about it in the book. But this is one of those areas where I think the WTO really needs to do a whole lot more. There is a negotiating group on this. It involves a goodly number of the WTO members. It's chaired by the Australian ambassador to the WTO, who is a very astute and knowledgeable man in this area. And there were hopes that at our now postponed ministerial in Geneva, there would be the announcement of a start of formal negotiations on digital rules. That's now a bit in limbo. They don't need a ministerial to make that announcement, so I'm hoping they will announce it soon, and they need to get going. Ultimately, regional approaches to digital trade are not enough. This is one of those areas that, by its very nature, needs to be multilateral in approach.
Great. So you've mentioned that these disputes have not been brought, and you are suggesting they could have been brought, and successfully so. And I guess I'm puzzled as to why not, assuming that the system isn't failed as it is at the moment, due mostly because of the United States not appointing appellate body members. But can you speculate as to why? Is it some sense that reciprocity would set in? That is, that if they brought a dispute, China would immediately challenge agricultural subsidies, and that some things should just not be brought to air because we're afraid that, states are subject to other challenges? Or is it lack of transparency, that we don't know enough about how forced tech transfer actually occurs to make a case? I'm curious.
Usually there are geopolitical considerations of the moment that hinder and constrain these endeavors. No one brings a case to the WTO lightly. For one thing, you want to make sure you're going to win, because you don't want to suffer the political fallout of losing. Mostly plaintiffs win in the WTO, but this is in large part because countries don't bring cases for the most part unless they're really good cases with solid claims. 70% of the cases are cases in which the complainant prevails. So that's a factor. But looking back to when we were trying to urge the Bush administration back in 2005 and 6 to bring a case against China, challenging its overall implementation of its obligations to enforce intellectual property rights. Well, the general policy of the Bush administration had been to give China a pass for a few years and beginning to gear up toward compliance because it was new to the WTO. And that, I think, is what the Bush administration would have wanted to do at the time. But at this juncture, the Democrats took control of the Senate. And my friend and former House colleague, Chuck Schumer, was now in the majority in the Senate, saying a whole lot of things about what we should be doing to China on trade. And Bush administration decided, I think rightly, that they didn't want to do everything Chuck was suggesting, but that they had to do something. So it was that point that they at last agreed with us to bring a case. But they wanted to bring narrow cases, or two cases. They wanted to bring narrow cases based on limited claims. First of all, in the hopes that we would win, but second of all, to minimize the disruption in broader relations with China at the time. This was a mistake. Had we been challenging China in the WTO 15 years ago and a dozen years ago, well, we wouldn't have had all the problems we have now. So there's always a hesitancy. I can't speculate now. I know with respect to the Trump administration, they just had no respect for the multilateral system. And President Trump and Ambassador Lighthizer simply preferred unilateral solutions. With the Biden administration, the jury's still out. On the one hand, they're still persisting with this phase one agreement, which I think is in violation of the WTO treaty, and with all of Trump's unilateral tariffs against Chinese products, which also are illegal under the WTO treaty. But on the other hand, Ambassador Tai is, unlike Lighthizer, gone to Geneva. She said that the United States wants to work within the WTO. There are qualifiers in what she said that sound like that in a softer, more polite way. They are still saying it's our way or the highway. But they seem to be preparing a mutual trade action of some sort against China with European Union and others. Is this action going to be within the WTO or is it going to be outside the WTO? We don't know.
So some observers agree with you and say that not much has changed between Trump and Biden when it comes to trade attitudes towards China, but the rationale has changed. So from an America First policy, we've gone to a somewhat different rationale, stressing human rights violations, stressing the treatment of Hong Kong, stressing the threat to Taiwan. Is that accurate? That is, that the rhetoric is now...
It's partly accurate. There is this additional rhetoric and policy. I don't think the Trump administration gave much thought to human rights in China or anywhere else. Clearly, the Biden administration cares about human rights. And that's one reason I voted for the president and why I continue to support him despite what I see as the shortcomings of their trade policy. But looking beyond that overlay of rhetoric, the economic motivations still seem to be the same. What is Buy American if it's not America First? Is this just the President Biden's way of trying to mute those who say he's moving away from America First by discriminating in favor of American products and public procurement? Or does he really believe this? I think he actually really believes this. He's always supported Buy American provisions, unlike me. And also, everything that they're trying to do as it relates to the economic aspects of trade seems to me to be the antithesis of support for free trade. It seems to me to be managed trade of different kinds. And a lot of what they're providing are are in their nature both as already enacted and as proposed, subsidies of a kind that are similar to those we're challenging by China. And I think those types of subsidies are wrong wherever they're provided. It's not a good economic policy, not to mention being, in many cases, against international treaty obligations. So I see in trade policy really Trump light, a polite form of protectionism, a change of style but not substance as it relates to the nitty gritty economic issues. The best example of this is trade remedies. This is the real grievance of the United States politicians against the WTO, the fact that starting with me and my colleagues and continuing with our successors, the Appellate Body has strictly upheld treaty obligations relating to anti-dumping and other trade remedies. For our own domestic political reasons relating to pivotal political states in the Midwest, where we have some smokestack industries that are challenged by trade competition. There's a bipartisan desire to apply those remedies widely, deeply, and if they can, with legal impunity. And the WTO hasn't allowed that. That's the real reason for the challenge by the United States, the Appellate Body, despite what those have been fostering and have said. So whereas I think that there's some good aspects of these innovations, the emphasis on trade and the environment, the emphasis on human rights, and some of the aspects of the emphasis on trade and labor. These are things that I would be doing. I think also there's a question as to whether a lot of this is just protectionism by another name.
So one of the things that I think you suggested, among many others, is that earlier administrations have gave China some deference because they were just starting out. But of course, one source of stress these days is that China retains developing country status. Some people think that that's something China could easily give up because it doesn't mean anything tangible. But other people think that this is a very important thing for China in terms of symbolism. It wants to be considered to be a developing country member, to be the leader in the WTO of the global South. What do you think about the developing country status aspect? Is this a negotiable issue on either side?
I think the WTO as a whole needs to revisit the whole issue of special and differential treatment. In my view, special and differential treatment should be provided on a temporary and transitional basis to enable countries, especially smaller, poor, least developed countries, to begin to put in place the institutional architecture to support freer trade before they're required to fulfill all of the obligations in the WTO treaty. So it should be used as a means of furthering the freeing of trade and the opening of economies, and we can hope eventually societies. Instead, for more than 70 years, special and differential treatment has been used as an excuse for not complying with a trade obligation year after year after year after year. And the victims of this are the developing countries. I mean, Donald Trump was right that he was a problem, that this is a problem. He was absolutely wrong about the reason why it's a problem. The United States doesn't suffer from this much at all, because as you pointed out, it doesn't add up substantively to anything in terms of affirmative advantages, especially in dispute settlement. But the victims of this are the developing countries themselves, because by being imprisoned in these closed societies in which there is a more restricted trade, they are prevented from being able to make the economic advances toward true economic development. And I would add today that in all discussions in the WTO from now on, the noun development should be modified by sustainable. I've written a book about that too. In terms of China, China gets nothing out of special and differential treatment. I think you're right that it's a symbol for China. China is still a developing country. Despite its overall economic impact on the world, there are hundreds of millions of people in China living on not very much still, despite all of China's economic advances. And I fear that some of those advances, as with the rest of the world, have been undermined during the pandemic. There need to be distinctions that are made. Why not have a country be seen as developed in one sector, but developing in another? Why not be treated as developed for one product, but not for another? I also think this should be done on a case-by-case basis. My co-author, Inu Manak, and I, in our book, The Development Dimension, have gone on to great length about how we think a new approach should be taken to this that would truly advance development. The bottom line is that there's absolutely no evidence over the course of 7 decades that the provision of special and differential treatment to developing countries has done anything positive for their development.
As opposed to participating in the WTO more generally. So you and I have talked about
the way to develop is to lower your barriers to trade and participate in the global economy. And I might add, this also applies to the United States of America.
So one issue that's come up in the Q&A a number of times is the criticism by the current head of the USTR that the DSB has become a judicial proceeding and that it should be changed to something more semi-diplomatic. And among the proposals that some make is that there should be a check on the appellate body, where some issues are thrown back to the members, the DSB itself. What do you think are legitimate complaints about the appellate body as opposed to illegitimate complaints?
There are a couple of legitimate complaints that deal with procedures that could and should have been dealt with long ago through something much less than an existential crisis. The length of time that the appellate body takes to produce an appellate judgment, the length of time that a departing appellate body member can remain in order to complete a case, and 1 or 2 other issues of that sort. But by and large, I would say the appellate body has done its job. In the Beltway in Washington, it's now almost universally believed on a bipartisan basis that the appellate body is routinely engaged in what's usually called overreaching, and going beyond its treaty-dictated role and inventing new rules and new obligations. That's not true. This is another instance of the big lie with which we've become so familiar in recent years. But one of my criticisms of my fellow Democrats in Washington is that while we've been so good at detecting and denouncing the big lie in so many other areas, somehow we bought into this one. The appellate body has simply been doing its job, and whether it reaches the right decision on a ruling, the right legal judgment in any particular case is one matter. But just because it may have reached the wrong result in a case doesn't mean that it was overreaching in making that ruling. The appellate body is required by the treaty to accept all the appeals that are brought to it. It has no discretionary jurisdiction, unlike the U.S. Supreme Court. The appellate body is also required by the treaty to address, it's mandatory, shall address each of the claims, each and every one of the claims that is raised on appeal. It can't say, well, we don't think this claim is necessary to resolve this dispute, so we're not going to address it. It does not have that right. So it has to address all the claims that are brought to it. Furthermore, the appellate body is specifically and clearly instructed in the dispute settlement understanding to take one particular interpretive approach, and that is to clarify the obligations in the WTO treaty in accordance with customary rules of interpretation of public international law. These customary rules exist independent of treaty convention, but they find reflection in the Vienna Convention on the law of treaties. And under Article 31, 32 of those of that convention, you see those rules. These customary rules provide that treaty obligations must be interpreted consistently with the ordinary meaning of the words in the treaty in their context and in the light of the object and purpose of the treaty as reflected in the treaty. I'm paraphrasing here. These rules therefore assume that treaties have an ordinary meaning, and furthermore that the obligations in the treaties have one meaning, not a number of them. So when the appellate body is specifically required in a mandatory ruling and a mandatory appeal to clarify an obligation, it has to identify the ordinary meaning of that obligation, what those words mean. This is not overreaching. This is the appellate body doing its job according to its instructions from the WTO members. And I would suggest that by and large, it's only the United States that has any quarrel with this. And it's only because the United States has misbehaved here that other countries are even coming up with proposals for reforming the appellate body. And as I said earlier, the United States is only bringing these charges against the appellate body because of our obsession on a bipartisan basis with rules on trade remedies, because those rules are important to the political outcomes in states named Pennsylvania, Ohio, Michigan, and Wisconsin. Have we heard those states mentioned before?
So one of our listeners, as paying attention to what you've just said, suggests that it sounds like it's very hard unless the Biden administration were to change its mind on the issues that you've mentioned about the dispute settlement and specifically zeroing in on trade remedies, for the old system to make a comeback, the dispute settlement system. Do you expect a way forward where you could still have a renaissance of the appellate body, but perhaps without the United States?
Well, it remains to be seen whether I've been a leader in a noble experiment comparable to the League of Nations, but of course, even the League of Nations was followed by the United Nations, and most UN scholars know that it largely built on the experience and the administrative apparatus of the former League. we've been without the appellate body for a while now, a couple of years. We had a couple of judges, but you need 3 to hear an appeal. So we haven't had an effective right of appeal in some time. And at the outset, I was for changing this immediately and restoring the appellate body to its rightful role immediately. Right now, I'm not in so much of a hurry. Yes, the system is crippled. Effectively, we're back in the days of the GATT. You can, as the United States has done when it lost the case hypocritically, filed a notice of appeal into the abyss, thus in effect blocking the panel ruling. So that's the GATT reborn, and that's not good. But if we were to restore the appellate body now, I fear that the temperament among too many other WTO members is that they are so desperate to have the United States back and fully engaged in other aspects of the WTO, and that they might concede too much to the United States in reconstituting the appellate body, and thus undermine the dispute settlement system and ultimately with it the entire trading system. So my current view is let's wait a while, because I think that questioner is right. If we try to do it now, we won't be able to restore the appellate body as we've known it. We'll be able to restore something that is much less independent, is potentially not impartial, and will not serve the role of clarifying the WTO obligations in a way that provides security and predictability for the trading system as required by the dispute settlement understanding. And recall what I said at the outset about the meaning of the rule of law and what's most important to it. What's most important to the rule of law is having independent and impartial judgments. And in my view, at bottom, the United States wants to be the judge and jury in its own cases. That's what it really wants. And that's why the United States, first under Donald Trump and now in the first year of the Biden administration, it has not been forthcoming enough to say what they actually really want. Because in a way, they're embarrassed by it.
So I guess that raises a question that one of our listeners is, and that's focused inside the United States. Will one party eventually embrace the notion of free trade again? Where's the leadership going to come from? And I guess one of the things that China must be paying attention to is what credibility does the United States have to recommit to the WTO if the current administration is not seeking and certainly not getting fast track authority to conclude more agreements, whether regional or WTO oriented agreements. So I guess it's a related question here. You're a former member of the House of Representatives. You know the politics here. What would it be? What does it mean not to seek fast track? What does that tell you if you're sitting in China about the U.S. seriousness on this issue?
Well, let me take the second question first, the question about fast track, and then let me go back to your interesting first question about which party will ultimately come forward, if either, to support freer trade. Now, in my view, any president of the United States of whatever party should have fast track negotiating authority. I would vote to provide trade negotiating authority to Donald Trump. The fact that President Biden is not even seeking trade negotiating authority reveals to me the mistaken premise of the Biden administration as it relates to trade. The premise seems to be that we can do what needs to be done now to get our economic house in order domestically. And then once we're ready, we can go out and negotiate, new trade agreements. The president, I think, has pretty much said that in something similar to those words. However, the world keeps turning. I don't think we can do what we need to do domestically to get our economic house in order if we don't have more opportunities from trade, if we don't have the spur of competition that comes from more trade, if we don't have the goods and services that we need as inputs into making ourselves more competitive in the world of trade. And I don't think the rest of the world will wait while we decide that we want to get serious about trading again. The greatest example here is the historical irony that the Chinese are knocking on the door to get into what's now called the CPTPP. And the Democratic Party and President Biden have dug themselves so great a hole on this issue through their past rhetoric that they can't even do the obvious, which is get the U.S. back into the CPTPP, which would be the best way to advance everything the Biden administration has said about the Asia Pacific area economically as it relates to the United States. On to your second question. I wrote an article a couple of years ago for the Wall Street Journal that they chose to headline, "Democrats, free trade is your destiny." Now, those who write the articles don't write the headlines, but I'm hopeful that one was correct, and I'm still hopeful. And some of the evidence I used in that article still holds. Look at where the strength of the Democratic Party lies in the country. It lies increasingly, and for the most part, in the urban and coastal areas of the United States that are most diverse, most engaged in the wider world, have the greatest economic output. In these areas, you see overwhelming support among Democrats for trade and Democratic support growing overall. Unfortunately, this is not reflected yet in the Democratic Party. The Democratic Party is still more representative of what I would say is the 1980s and what used to be the American economy, largely because of the influence of my friends in a lot of the trade unions. Unfortunately, labor is organized only to about 14 to 15% in this country, and it's tending still to shrink more. I don't think that's a good percentage or a good direction. And if you look at organized labor, well, much of it's increasingly in public employees, and I'm absolutely in favor of that. But to the extent that it's in the private sector, the labor unions failed in the 50s, 60s, 70s, 80s to organize among a lot of the rising industries, and especially the service industries in the Sun Belt, from the Southeast across to the West Coast. And they're paying for it now, and that so many of the venerable older traditional unions have a membership that's mostly reflective of the older parts of our economy that are finding it harder to be more competitive, or are becoming much more competitive by shutting jobs and automating. Automation is a much bigger economic issue for the American workforce than trade. That's a topic for another day. But the AFL-CIO has an outsized say in the Democratic Party. And again, I come back to those same pivotal states. And this is reflected in the trade policy of the United States in a Democratic Congress and also in a Biden administration. The president, to his credit, has always been a strong supporter of labor and working people. But unfortunately, the labor unions, because of the overall challenge they face in maintaining a job base in these challenged parts of our economy, have long since turned against trade. And that's where we are with the Democratic Party. But when the Democratic Party begins to more accurately reflect the views of the majority of Democrats in the country, I think you'll see the Democrats turn back more towards freer trade. I'm not as hopeful for the Republican Party because the Republican Party seems to be being in the process of digging deeper into the hole of isolationism, economic nationalism, the xenophobia, and all the other dirty dimensions of Trumpism.
Fascinating. It's not the answer that I would have thought, but that's really quite
Well, as
interesting.
you mentioned, in my errant youth, I was in politics.
Yes.
And I should add, I've never lost an election.
So no, you obviously have a keener sense of the things. So Jerry Cohen, who's my predecessor, has a question, which I think I should just pose because it does echo a lot of other questioners. So he says trade is one of the few major areas that divide the US and China that offers some prospect of compromise that might actually improve relations between the two countries. And I guess he wants to know, as do others, what specific proposals would you make to pursue negotiated reentry between the US and China back into the WTO? What areas of reform you think they both share? Or you've written on so many issues, including climate change and the WTO, how trade can contribute on pandemics. Is it negotiations based on those specific issues? So how would you answer Jerry's question?
Well, the number one issue we should have been negotiating in the WTO in the past 2 years is the one that our current Director General, Dr. Ngozi, has highlighted, which is trade and health. And there, I think there is ample room for the United States and China to come together. As you mentioned, I've laid out in various papers and long lists of what the items on the agenda should be, and I have a chapter on that too in my forthcoming book. But we should begin by eliminating all tariffs on all medicines and other medical products. We should eliminate all export restrictions on medicines and medical products. And we should develop more mutual recognition agreements and common standards relating to a lot of these products. This is certainly in the mutual interest of the United States and China's mutual interest of the entire world. So that's what I would put first on my list. But also, I think there is room for compromise on climate change. If China doesn't get its act together on climate change, then we're not going to solve that problem. China's now the leading emitter in the world, but it's also important for us to realize we're the leading historical emitter. And there are lots of countries that have suffered a lot because of that and are suffering now. One of the ironies of the climate change issue is that those smaller and island state countries that have done the least to contribute to climate change are now on the front lines first and having to deal with the consequences of it. And why aren't China and the United States working together to try to help those countries? A whole lot more than we are. I could go on, but I see many opportunities for China and the United States to work together side by side. And I think it's important that we continue to trade together. I was not one of those in the 1990s who thought that China was going to suddenly wave the red, white, and blue and become an American-style democracy. I would love for that to happen for the sake of the Chinese people who deserve freedom. and have suffered millions of lost lives because they haven't had freedom during the communist era. But I think there is, even in spite of our very real differences on democracy and human rights, the opportunity for us to trade. A new topic in trade is trade coercion. And ironically, the Chinese have been engaging in some of this with Australia, imposing trade restrictions because the Australians have been so courageous as to tell the truth about what China's doing in Xinjiang and elsewhere. And of course, China will suffer the most from this kind of trade coercion. So I don't think they're thinking clearly there and trying to engage in it. But that's what we need to keep out of trade. Trade needs to continue among countries, even when they have very real political differences. That was a core view in the trading system from the start. This was the view of Cobden and others back in Victorian England nearly 200 years ago. And it's my view now. I think that it is true that nations that trade together are less likely to engage in martial conflict. And I think it is true that trade is not just about goods and services. It's about mutual exchange. It's about communications. It's about building trust. And I think that can provide some tangible benefits in the form of what amount to public goods in the dealings between countries that are otherwise at odds. So I continue to be an optimist in thinking that China and the United States can somehow find a way to work together for their own good and for the good of the wider world.
Well, that does sound like trade dialogue is also peace dialogue. And it sounds a bit different than what some people had, as you point out, aspired to at the beginning when they thought that trade dialogue was democracy dialogue, that it would change your governance. And I hear a somewhat different take from you on that score. Now, there are many other questions in the chat box. We are getting towards the end, and we do have a tradition of ending on time. But there are a lot of other tensions between the two states. And I'm curious if you want to say anything more about some of them. Among them is national security concerns, how the CFIUS operates, the Committee on Foreign Investment in the United States, which has been focusing almost entirely on Chinese enterprises, the China Initiative at the Justice Department, which seems to target Chinese academics and others. And there are big concerns about China's goals under its Belt and Road Initiative, now affecting over 140 states. Are you particularly concerned about all those things? Have we overstated the national security threat? Are we too fearful that China has become an economic giant that will overwhelm us? Is that part of what the tensions are all about? Anything you want to say on those things?
Well, as one of the great liberal writers and thinkers and politicians of the 19th century, Thomas Macaulay, once said, the challenge in governance is about drawing the right line in between. What he meant by that is that the answer is often not found in the extremes, but in some measured point between them. I think this is true about our dealings with China as it relates to national security. We cannot be naive. I don't think China's trying to conquer the world militarily, but I do think that the Chinese government under Xi Jinping does want to have its say in its way in a good part of the world in which we Americans have some very real national security interests. Therefore, I think we have to be careful on technology issues, especially advanced technology, as they relate to national security. At the same time, we can't approach this as the Trump administration did. We did a lot of specious claims about justifying trade restrictions with China and other countries on the basis of national security. Importing a Mercedes-Benz from Germany is not a national security question. And yet that was the view of the Trump administration. Whereas the Biden administration on all of this, we'll see. We look at what China's doing in trying to invest in advanced technologies and the progress that it's been making in recent years. We quite rightly point to the transgressions of China as it relates to some of the trade rules in terms of their discriminatory practices and some of their demands, such as with technology transfer. But China has the right to advance economically. Our problem is that we haven't been investing here over the past generation in basic research and development and in improving education at all levels, so that we will continue to advance and will retain the leadership we have in so many areas of advanced technology. We continue to lead in nanotechnology and aerospace and medicine and in other areas, but China is rapidly advancing in artificial intelligence and semiconductor chip making technology, in electrical vehicles, solar energy, and a lot more. We shouldn't be trying to stop them. We should be trying to do the same ourselves. That's the kind of competition we should be having with China. It should be a competition in innovation. And there, I believe that our basic market-oriented approach works far better than the statist approach of the Chinese. So instead of trying to emulate what they're doing by throwing out our own subsidies willy-nilly, we should be defending and employing the economic approaches that we say we believe in. And we haven't been doing that. But yes, I think we have to be very careful in terms of protecting our intellectual property, in terms of being mindful of highly complex issues related to international commerce in advanced technologies.
Well, that'll have to be the last word. Thank you, Professor Bacchus. We will hopefully see you again. Certainly when your next book, we will try to get you back. Thanks very much. And thanks to all of our listeners, especially for your great questions. Take care and have good holiday season, and we'll see you next year.
Thank you so very much.